So my name is Emily Kile. I am a partner here at Mushkatel, Gobbato, and Kile, and I'm joined today by Matt Gobbato, who is another one of the partners here at the firm. So thanks for coming in today, Matt.
Yeah, thank you for having me. Good afternoon,
How
everyone.
can I help you?
I don't know what that is. So our first webinar with the new firm, and we're already having technologically weird things happen. I have this extra Emily voice thing. Anyway, so we're going to talk today about basics of estate planning. We, from my perspective, for me, Emily, Kyle, we're still in our Scottsdale office, and my team is the same. And Matt and his team and Zach are in Sun City, although they come to the Scottsdale office on a regular basis. So one of the nice things about this merger is we now have two different offices so we can cover the whole valley. And we still focus on estate planning, guardianships, and conservatorships, probates, trust administration, but we now have the added advantages of being able to do some contested work. So if people don't get along, whether it's a personal injury, a financial exploitation matter, or a contested guardian or conservatorship matter. We also have an attorney now who does family law, so divorce and custody issues. So we've just kind of added to our repertoire of the things that we're able to do. And of course, we continue to do Altex work and helping people get prepared for Medicaid services. Before today's webinar, I did get two questions from various people. Both of them are totally related to Altex planning, which we're really only going to touch on today for a very short minute. If you search for me on YouTube, I have a lot of videos, or if you go to the website for the law firm, we have some of those videos on there as well. And some of them do cover Altex in a lot more depth. If we have time at the end, I am more than happy to try and delve in a little bit with the questions that came up, both of which are very related to kind of how do we preserve assets for the well spouse. So we'll see if we're able to get to that or not today. So today, as I said, we're going to focus on estate planning. I just want to remind everybody that even if in fact you really are a client of the firm, for today's purposes, we do not represent you. Please understand that this is very general information. Everybody's situation is totally different, and we hope that you will get whatever appropriate legal or other professional advice you feel is necessary before you do anything. So remember, this is an overview, and I am not talking to you directly, even if it feels like it sometimes. So we're here just to provide some general information. So estate planning is kind of a very, very broad topic, very broad scope of what we think of as estate planning. Oftentimes, clients will come in and they'll say, I have a trust, which includes all of my other stuff, and I need to just update my trust. But we like to think of the estate plan as the whole ball of wax of things. That is, we're going to talk about healthcare powers of attorney and financial powers of attorney and living wills. And what does all this mean? And the difference between wills and trusts, and what's a conservatorship? So obviously the goal of having an estate plan is to be able for you to maintain control as best you can while you're incapacitated, making sure that we have the right people in the right place to make decisions for you when you can't make those decisions, whether that's due to incapacity or death, figuring out the most efficient way to get what you have to the people that you want to have it. And then in some cases, protecting potentially those beneficiaries from themselves and from their own vulnerabilities. So we're going to start with talking about healthcare decisions. And I think it's really important to think about this because this is while you're alive. Like where your stuff goes when you die, I get that that's what we all get wrapped up in, but you'll be gone, right? So we want to make sure that we have in place the right people and we've provided the right set of instructions for when you can't speak for yourself and we're talking about your healthcare decisions. This is not just about a pull the plug, stop, heroic measures kind of thing. You might have dementia and a decision needs to be made about whether or which kind of antibiotic we use. You might be in an accident and you're unconscious, and somebody has to decide what that treatment's going to look like. Maybe it's about placement later on. You're not able to stay at home by yourself any longer, and it's arranging for those long-term care services, somebody coming in to help you, or you going to a facility because that's the most appropriate kind of place for you to live. So when you're thinking about who should make those decisions, I hope that you will think about it in a broader sense and not just who's going to make the decision about when you're not going to put me on a ventilator or take me off the ventilator or whether or not I want food and fluid. We're going to talk about those decisions in a little bit as well. Obviously, all of you know about HIPAA. It's been around forever. Those of you who have really, really old powers of attorney, which we see sometimes, and they don't have HIPAA releases in it, that will make it very difficult for anybody to communicate with you and your agent. So really important just to make sure that's in there. We find also that sometimes there are no HIPAA releases related to your financial documents. And your financial agent might need to see your bill from the hospital that will include information that might otherwise be protected about what your treatment was to make sure that if you went in for a broken leg, that the bill isn't coded to say that you went in because you needed ear surgery, right? So that HIPAA release should be in more than just the healthcare power of attorney. It needs to be broader. And most often in our offices, we also do a separate HIPAA release so that in the event that you are not incapacitated, but maybe you need somebody to go get medical records and transfer them from one provider to another, that they would have the authority to go ahead and pick up those medical records and get them where they need to go for a second opinion or whatever that might look like. So we like to see those releases in all the documents, not just in your healthcare documents. One of the main reasons, I guess I would say, for having any estate planning documents is, again, so we understand what your wishes are and what your goals are. The other thing is about making sure that we can reduce conflict. So if you have named your eldest daughter to be your healthcare decision maker, we all know she's the one who's going to make the choice. She might have to deal with her other siblings who might disagree with her, but we know that that's who you wanted when you were competent and were able to make the decision. And so that's who the medical providers can look to. Sometimes it is about end-of-life choices, or it's about alleviating guilt for making decisions that would make somebody uncomfortable, but they know that you've chosen them, that you trusted them to make decisions that you believed were in your best interest and the way that you would want them, or at least you trusted that person to look out for your best interest. We don't want to end up in a situation where we don't have a decision maker, and then we have to go to court and get somebody appointed in that role. In Arizona, we have a Healthcare Surrogacy Act. And so that Healthcare Surrogacy Act would put the spouse as the primary decision maker if there is one. And if there isn't, then a majority of the children. And then it goes down from there. Somebody you live with for, I think, the last 60 days. So then there's a list. But having a healthcare power of attorney tells us who you really wanted to make the decisions. And if there's conflict between your kids, it is not going to get any better when you're not around. So you can also add in an additional document that expresses what your wishes are. You can express that you have looked at facilities and this is the kind of facility you would like to be at, or that you want to stay home and you want caregivers to come into your home, or you want your sister to come and she should be paid for those services. Whatever those decisions are, you have the right to speak when you can't by having these documents done and appropriately signed and adding any additional kind of letters of intent that you think are important. Arizona is a unique state in lots of ways, but one of the ways it is also unique is that we have a separate mental health statute. That is a statute about being able to involuntarily admit a person to an inpatient psychiatric hospital. That is a licensure issue. So it's not just going to the medical hospital, but they are licensed to treat psychiatric conditions and would have awake doctor and RN at all times. And usually those stays are very short, 2 to 3 weeks, to get somebody maybe to reduce their anxiety or whatever. Maybe they're having a reaction to the medication they're on. And so to make sure that we can get them back to wherever they were living or an appropriate living environment. It's not where you live forever. It doesn't have anything to do with going to a memory care center or an assisted living facility. It's a short-term stay. If you needed that kind of treatment and we don't have a mental health power of attorney, then somebody has to go to court and be appointed as your guardian, even if you had a general health care power of attorney. So you can have a separate mental health power of attorney, or you can have it as a provision in your healthcare power of attorney that's very specific about that authority, and it has to be initialed by you. So if you're looking at your healthcare power of attorney and you don't see any place where you added initials, you do not have this authority in your documents. We have found recently that the psychiatric hospitals like to see a separate mental health power of attorney. So we have it typically both in the healthcare power of attorney with a separate paragraph and as a separate document. Just because we found that that's what they're looking for, and we want to make it as easy as possible for you to get the treatment that you want without us having delays or having to go back to court. Per the slide, there is a free form at the Attorney General's website. They also have a free healthcare power of attorney and a living will. They're very basic, but they're free and they work just fine. So you can certainly go there and make sure you get that done. The healthcare power of attorney, mental health power of attorney, and living will only require a witness or a notary who is not the person taking care of you and is not the person who would be your agent. And we recommend they not be a relative so that there's no question that you are unduly influenced in who you chose. But it definitely can't be your agent, and it definitely can't be your healthcare provider. So they're really easy to get done, is my point. They can be a witness or a notary. You don't need both. Living wills, sometimes called healthcare directives in states, that's your end of life decision document that we talked about at the beginning. So that's your opportunity to either be super broad, which is to say it's okay to stop heroic measures in the event I'm not going to recover from my terminal illness, vegetative state, coma, whatever it might be. You can be super specific. We have templates where it's each thing. If I need minor surgery and I have dementia, if I need major surgery, if I need antibiotics, and then each kind of condition. Oftentimes, having a broader living will might work better because we have no idea how all those things are going to come together. And we don't want to worry that we need court to intervene to say, well, is this major surgery or is this minor surgery? Is it due to the stroke or the dementia, right? So all of those things can play into the decisions, but whatever you want and you feel comfortable, and most importantly, that you've discussed with your family and decision makers, because you won't be there to say, yeah, this is what I was talking about. I definitely want treatment right now, or nope, I am all done. I'm having a perfectly fine time in my coma and it's time to end things. I don't want to be around anymore. So this is your opportunity, and it's really important for you to talk to your loved ones so they know what your wishes are. Your wishes might change over time. If you're 25, you might have a different perspective than when you're 90. All of the documents, as long as you're competent, are amendable and changeable. So update them, review them, take a look at them, make sure they're still what you want. So just keep that in mind. And again, make sure you've discussed those decisions with the people who are going to be involved in the decision making, and maybe the people who aren't, but are the ones who are going to question the decision maker. So obviously, we also want to plan for what we do with our finances. So if we don't have a way to access your money, um, then a conservatorship may be what's required. That is a court proceeding when we have somebody who is incapacitated and somebody needs to access funds. Sometimes we find that um, maybe all of the accounts are held jointly with another person, but then we have the one IRA and there's no financial power of attorney, and an IRA is never titled in the name of a trust. So now we have an asset that nobody can access. And so it might be that a conservatorship is needed because we have one asset that we need to take care of. Sometimes it's everything. We have a person who has a house and bank accounts and investments and a car and all of this other stuff, and nobody can do anything to pay the bills for this person. So that is a conservatorship. We like to try to avoid them when we can. They're obviously not inexpensive. Most of the time, you'll need an attorney to be involved in that because of the accountings and bonds and all of the other things that are required as part of that conservatorship. They do take some time unless we have an emergency, meaning that we can't pay the bills and therefore that person's food and shelter needs cannot be met and we have an emergency to get in front of the court. It is public for the most part. Sometimes, for example, if there's a settlement, a personal injury matter or wrongful death claim for a minor or incapacitated person, those might be confidential, but otherwise everything is public. Somebody can look up all the paperwork and see what's happening in the case, what the assets are. Obviously, none of us really probably want that to be us, but that's how conservatorships work, and they can certainly be stressful. You're dealing with enough when we have an incapacitated loved one. Now you can't access their money, and then you have to talk to Matt and I about what is it we're going to do? How are we going to get there? These are all the documents you need to sign. This is all the information we need, and you have to be at the court hearing, even if it's virtual. So trying to avoid that is probably in your best interest. So how do we do that? Well, we're going to talk about trusts in a bit, but if we have assets that are not in a trust, and as I said, things like retirement assets are typically not in a trust. Life insurance, unless you have a life insurance trust, are typically not titled with the owner as the trust. A financial power of attorney document, sometimes called a durable power of attorney, sometimes called a general power of attorney, sometimes called a special power of attorney, sometimes just called a power of attorney. Whatever it might be called, we have to look and see what the language is. And this is the opportunity to delegate the responsibility over the finances to somebody else, whether that's a friend, a licensed fiduciary, whoever that might be, for that person to then manage the funds. This can go into effect when one doctor says you're incapacitated, two doctors say you're incapacitated, there's a panel of people, family members and the doctor. We don't know what it says. We don't know what the rule is until we see what the document says. And they can be drafted in a whole host of ways. There are times also when the power of attorney says that it's effective upon the date it was signed. Our experience has been that's great, but most of the time a financial institution, even if it says it's effective immediately, is going to then require you to come in and say, hey, it's okay for this person to have access to my money, because the bank wants to feel protected, that they're not just giving access to a stranger to your account, you being the customer. The other thing is that we want things to be practical. We don't want to just give you a book of paper and then none of it worked. It's not helpful. So we always recommend that you go to the bank, wherever the money might be, the life insurance company, the bank, the brokerage account, whatever it is, and say, hey, if I become incapacitated, this is my financial power of attorney. Is that going to allow my agent to access this account when I can't be here because I'm incapacitated? And sometimes they'll say yes, and sometimes they'll say no. It needs to be on our form. We need you to sign a certificate that says this is a valid power of attorney, and we're going to keep it on file. Sometimes they make up rules like it's too old. There's nothing in the statute that says they expire. So unless your power of attorney says it's only good for a certain period of time, it shouldn't expire. But we need to know that because we want it to be practical. If you draft your power of attorney and you sign it and you don't look at it again because it's fine, and in 15 years you have dementia and the bank says, well, we have a 7-year rule, that would be very uncomfortable. So we do recommend that you at least show it to them. Some of the financial institutions are even more annoying and they say, I can't tell you right now. When the event happens, we'll have to determine whether or not it's going to work. And all of the financial institutions will send it to their back office. And so off it will go to customer service and it may take some time before we have an answer. But I do think that's an important thing to do. We sometimes see powers of attorney. So everybody who's used our services knows that our financial power of attorney is really, really long. Like, I don't know, 25 pages. It's really long, however long it is. And sometimes people say to us, this is dumb. It's too long. I don't have this kind of asset. I don't have securities. I don't have a business. I don't have. First of all, we don't know what you will have at the time you become incapacitated. And if you don't have it, you don't have it. But wouldn't we prefer to have too much than too little? We don't want that we're missing the one power that your person needs to go and do what they want to do. So sometimes we see in kind of I would say off the internet kind of documents not written by an attorney, things about, it doesn't say anything about being able to sell real estate. What do we do about the care for pets? Is it okay to use your money to take care of your pets or your dependents? Maybe you have minor children or incapacitated children and you want to make sure that there's support for them, or to do gifting. The power to fund a trust is not only super important if you have a trust and we need to move an asset into the trust, but from an all-tax standpoint, all-tax being the Arizona long-term care system, which is to pay for long-term care through Medicaid because you don't have sufficient assets to do that, or you don't want to impoverish your spouse in that process. We need this provision if, for example, your income is larger, higher than the monthly income that is allowed underneath the all-tax rules. So having a provision that allows for the creation, appointment of a trustee, and funding of something called an income-only trust or a Miller trust is important in your financial power of attorney document, because otherwise there won't be anybody to sign the trust, and the bank will typically not allow you to open the trust account if we can't show that you had the authority to transfer that income stream into the trust or serve as trustee. And then we might have to go to court and spend a whole bunch of money in order to get the authority to move the money into that income-only trust. I want to be super clear that you do not set up an income-only trust until we are ready, because you need all tax, and only in the event that your income is too high under the income limits. Those are the reasons we do income-only trusts. And it is clear in the all-tax manual, you may not add any principal. That is, you can't put an asset, you can't deposit extra money into the income-only trust to get you below the $2,000 asset limit. It is only for income. That is its only purpose. So again, at the beginning, I said we're not giving legal advice, just general advice, but I don't want you to do anything as a result, but I want you to understand what the concepts are. We might also need to deal with your credit cards and make sure that we can work with the Postal Service to get any mail forwarded. So those are some things that sometimes we don't see. Remember that a financial power of attorney requires a witness and a notary, and they cannot be the same person, because we have seen those too. So you need a witness who is not the notary, and notary cannot notarize their own signature. Those people, again, should not be the agent, and my perspective is they shouldn't be related to you. They shouldn't be the people who are going to take under your estate, so we don't have any questions of undue influence. So the other thing is, people often ask, can I have more than one agent? And I should have said this on the healthcare slide. So you can definitely have more than one agent. The question is, does it make sense to do that? So from a financial standpoint, if you have, say that you require 2 signatures, the bank doesn't know that. So they're going to let a check clear. They're going to let a wire transfer clear. They're going to let whatever transactions are going on in that account, those are going to continue to happen. And If the two agents disagree, the bank doesn't know that. Your financial institution's not aware of that. The only time that something could be halted is the sale of a house. The title company is going to read that power of attorney and require that they both sign off if that is related to the sale of real property. My preference would be that you have people in order. So if one can't do it, then the next, then the next, then the next. On the healthcare documents, we often make those or because it might be that a decision needs to be made and it's an emergency. And so we want to say this person or this person can do it. You don't have to. You can have joint decision makers on your healthcare documents and your financial documents. You can just list them in order, that it takes some kind of an affidavit or a death certificate before the next person can step in. Just think again about the practical nature of why we have these documents. Now let's switch to a trust. These are also called all kinds of things, right? They're called living trust, family trust, revocable trust, joint trust, marital trust. So the question is your money in it? Are your assets titled to the trust? And what is our purpose? So a trust is like, I like to think of the stack of paper as the rule book. This is the rule book about what we do with Emily's trust assets if she is incapacitated or deceased, because otherwise nobody knows what a trust is. It's those documents tell us who is it that has access to the assets and who is going to benefit from the assets that are titled to the trust. So when I say titled to the trust, that means my brokerage account says the Emily Kile Trust. That means the deed to my house says Emily Kile, trustee of the Emily Kile Trust. My bank account says the Emily Kile Trust. If I have my beautiful binder with all my documents in it, but all of my accounts still just have my name on them, even though I have a trust, there is going to be some process that's going to be required in order to get them into the trust. So in this little slide, into this chest, right? They don't just get there on their own. The way we get assets into the chest is to retitle them, or the trust becomes the beneficiary of those assets. With most retail bank accounts at this point, that is checking account, savings account, your credit union account, most of the time, if you get a trust after you've established those accounts, the financial institution is going to require that you close the account and open a new one in the name of the trust. Now all of your auto deposits and auto withdrawals are all messed up. So for those accounts, I typically say that you should go ahead and just name the trust as the beneficiary on those, which you do right at the financial institution. For real property, that can be retitled, and then the deed is recorded with the county where the property is located. For investment accounts that are not retirement accounts, you can work with your financial advisor or with that institution to get those accounts titled into the name of the trust. And then for retirement assets, you would want to have a discussion with your CPA and financial advisor as to whether the trust should be the beneficiary or individuals. Part of that depends on the age of the beneficiaries, their ability to manage the funds, and some tax considerations. So you should talk to, again, your CPA and financial advisor about that. Because trusts don't die, they don't require a probate process in the event that you pass away and the asset is either titled to the trust or the trust was the beneficiary, because we already know where it's going to go. And we already have our trustee, the one who manages the assets and follows the trust document, which is the rule book, about where those assets are going to go. As with all of these documents, it's really important that you tell the people who you have named that you named them and tell them where the documents are located. If you're not comfortable giving them the documents while you're alive, you might change them, or for whatever reason. You don't have to, but it is really important that they at least would know where to find them. For the healthcare power of attorney and living will, I suggest that you give them a copy of it, again, because there might be an emergency. I think the healthcare power of attorney should include at a minimum a phone number and potentially an email address for the person so the doctor or somebody can also locate that person. and perhaps have a copy in the glove box of your cars. So if there's an emergency, you have that. You can show, hey, my mom's in the hospital. I'm the power of attorney. Here's my document. The same is true of the trust. Somebody needs to know where to find it. So I say you have to have a wealth transfer plan. I understand that most of us are not multimillionaires. And so when I say wealth transfer, I'm talking about your stuff, whatever that is, your bank accounts, brokerage accounts, whatever those assets are. The goal of the trust or of the will is to figure out who gets it, who gets the benefit of my money. And then to make sure that it's potentially about, well, what are those assets? So if you have a house and a bank account, well, if you give your house to somebody and your bank account to somebody else, does that mean that they have to sell it in order to continue to pay the mortgage, pay the taxes, utilities, deal with the broken air conditioner? So thinking about if you think in specific assets, you want to make sure that that makes sense for that beneficiary. If you think about all of it as just money, it's a house right now, but it can be sold and liquidated, then maybe you're going to set up your beneficiaries in a different manner. If you have minor kids or somebody where you want them to have the right to live in the house, you again would want to make sure that there's sufficient liquid assets to pay for all of those expenses. And you would want to be specific about how long does that right last, when they graduate from high school, when they turn 25, whatever that might be, right? If you have a beneficiary with special needs, meaning that they are on public assistance, then maybe your trust has a separate trust that's a special needs trust for that beneficiary or a subtrust of your trust. Our preference is to have a separate document. It's much easier for reporting to the government agencies, getting a tax ID number when money goes in it, having people name it as a beneficiary of life insurance and retirement accounts. And I recently had submitted a trust with a subtrust to Social Security, and they wrote back and said there's no trust. So when you have a separate trust drafted, you can resubmit. So then we had to do something called decanting, which is just meaning we had to draft a new trust and not argue with Social Security that the subtrust was fine. So we really do prefer to have a separate trust document. As we talked about, we want to make sure that the assets are titled to the trust, that they're not just in your name. Nothing happens by magic. So it's not magically a trust asset because your fantastic attorney wrote a trust document. I can't change your bank account. So you need to go and make sure that those steps occurred. Understand if you own an asset jointly with another person and you pass away, your trust and will are irrelevant for the most part. That asset is going to go to the people who are still alive and are named on that account. If you made a beneficiary designation, you named your sister as your life insurance beneficiary, and you said, hey, can you just make sure you take care of my kids? That's really nice. It is her money. And so she might have a mortgage to pay. She might have debts to pay. So be conscientious about who you've named as a beneficiary or a joint owner. Lots of our clients will have kind of, I'd say, their working account at the bank, their checking account with only a nominal amount of money in it, and they've named somebody else on it. So if there is an emergency, we don't have to wait for a doctor's letter or a death certificate. They can access the account and continue to pay the bills. But understand when you pass away, it is their money. Most people are ethical and they're going to follow your trust and divide it equally, but just understand from a legal perspective how that might work. So do you understand your estate plan? Most people trust us. We love that. We're so honored and appreciate that you believe in us or you're the attorney that you're using. But it is important that you at least spend the time for somebody, hopefully your lawyer, to have explained to you, even in a general overview, this is who you've picked. Is that still who you're comfortable with? This is where you want your money to go. You have it outright to this person. This person's going to get some at 20, some at 25, and some at 30. Does that still make sense for them? This thing says if this person's deceased, it's going to go to their kids. Did you want it to go to their kids or do you just want it to go back in the pot? so that you at least have a general idea. Nobody expects you to understand generation transfer taxes and other, rule against perpetuities and all these weird things we have. That is for your attorney to make sure that's going to work for you, but you need to understand the basics. You need to at least know where to find the basics in the documents. So people, for whatever reason, get really worried about death taxes. So I just want to be clear, first of all, how we figure it out. So we have to look at what the value is of all the assets that are in your estate at the time that you pass away. So whatever those values are, those date of death values, that's what we're going to look at for what your estate is worth. However, in order to have any estate tax, you'd have to have as a single person an estate worth more than, the numbers just came out. I think it's actually $14 million, but it's just rounding or unrounding. So you have to have a lot of money before we have to worry about estate taxes. And under the current rules, we, first of all, don't have any separate state estate taxes like many states back east. And if you're married, you get an exemption for you and exemption for your spouse. And I say if you're married, just because you love the person you live with, just because you went and had a lovely ceremony, and just because you wear a ring, does not make you a married person. Only if you have a certificate in Arizona. Don't have common law marriage. You can live together forever and you're not married. We sometimes have clients come in and call themselves spouses. And when we dig deeper and ask for the date of the marriage, we find out, well, we're not actually married. It's really important. It has huge tax consequences, and we want to make sure we're doing the right plan. The reason I put on there how complicated is your estate plan is that we sometimes see really complicated estate plans where half the assets go in the survivor's trust, assets go in a decedent's trust, maybe assets have to go into a bypass or a Q-tip trust, all done when the estate tax was super low, and that was the way that we could avoid death taxes. That's not the case anymore. So I do recommend, if you have an older estate plan, that you go to your attorney and have it reviewed to make sure that maybe there could be a simplification without the loss of tax planning or any protections we might need. There might be reasons that your trust should split into different things when you pass away, but we want to make sure that it makes sense. So you all know we do a lot of special needs planning. We have a lot of clients who have loved ones who have a special need, meaning that they're on government assistance, or maybe they just need a little extra help, and we want to set up a trust that's going to work for them. Additionally, you might have minor kids or neurotypical adult children who should not receive anything when they turn 18 years old. So in your plan, you can set up how they get the money however you want. Again, be practical, right? If you want them to get an allowance and they're not on government assistance, we can make that happen. If they are on government assistance and we need to make sure it's in a special needs trust, we can make that happen. If you are the grandparent of somebody who, if you are the grandparent and your grandchild has special needs, you probably want to talk to their parents about whether that individual is getting public assistance, whether or not those parents have set up a special needs trust, because then you could direct that inheritance to that trust so that their benefits remain in place and that we haven't done anything to disrupt those benefits. So family discussions are important. They might be a little uncomfortable, but they're really important. You don't have to tell anybody how much you're leaving, but if a person is on SSI, supplemental security income, DDD or all tax benefits, and they receive more than $2,000 as an outright inheritance, they risk losing those benefits. If the benefits go directly to the special needs trust because that's what your plan said, you can leave them $10 million and they can retain those benefits. So really an important point for sure. I had a conversation with a client the other day. We had drafted a third-party trust a long time ago, specifically because grandma said she wanted to leave money to this grandchild. We had provided all of the information to that person about how their will or trust should be set up so that the money went in the trust. Grandma just died recently, The mom called me and said, I think she just left it to my child outright. We were trying to come up with all kinds of creative ideas as to what to do with the money, but then she sent me grandma's will, and it was exactly right. It goes right into the special needs trust just like it should have. We didn't have to worry about spend downs and able accounts or anything else. So that was really, really nice to hear. You can set distributions up so that there are some strings, meaning that maybe they have to meet some criteria. Maybe you want to set it up so that the trust matches their W-2 income in order to encourage them to make sure they work. So you can set it up how you want to. We just want to make sure, again, for those special needs beneficiaries that we're protecting whatever those benefits are and we don't have a loss of those benefits. As I said, you can have a third-party special needs trust. That's the one that you do as part of your plan, part of your will, subtrust of a trust, but I really prefer that you make sure you are willing to do a standalone special needs trust. These do not have any payback to any state Medicaid agency for any reason unless somebody wrote that it was required. But it is not required by statute, and it doesn't matter how much money, how much or how little money is in there. It should work so that that person does not lose their benefits. Only for a first party special needs trust. That's the kind where it was the beneficiary's money, personal injury settlement they received, an outright inheritance they received. That's the kind of money that has to go into a completely different kind of special needs trust. And that's the one that has the payback that people don't want, but we can't afford if the money, we have to have if the money comes directly to the beneficiary who's receiving those benefits. Lots of rules about those first party trusts, when they can be funded, can't be funded after age 65. Lots of limits that we have to get permission from Altex to use those funds. If the person's on Altex with a budget, we have to do annual accountings to Altex. For SSI, if they're not on Altex, we don't have budgets, we don't need their permission, but we still do have to report the money, the trust, to both Social Security and Altex if they're on those benefits, whether there's money in a first-party trust or a third-party trust, but not until there's money. So if it's part of your estate plan and there's no money on it, please do not tell Altex or DDD on your renewal that you have a trust for the benefit of your child. It only has to be disclosed when there's actually money that's titled to the account, because there's no way to prove later to Altex when there is no account, because they will say, we need the account. Well, I don't have an account. Well, you said you had a trust. And it just goes around and around in a circle. So don't tell them unless there's money in that trust. One of the biggest delays in administration is somebody trying to follow your breadcrumbs. Where's the money? What are the accounts? What are the debts? Do you have a storage unit? How do I get into the storage unit? Is there a code? Is there a key? Who's paying the bill? Where is your mail going? Like the things that you just do every day normally, nobody else will probably know about unless you leave clear instructions. So, like I said before, you have to tell the people who are going to be the decision makers, they're going to be the decision makers, and you need to make sure you include a list of your assets and liabilities and that you update that on a very regular basis. If you own stock certificates, it'd be nice if you didn't. If you had them in book form, meaning that they're in an investment house. They're a royal pain when you pass away to get them. If you had them in stock certificates and now the certificates are lost, then a bond has to be posted, a medallion signature on a bunch of forms. It's a pain in the rear end. So most people don't still have the certificates, but I would encourage you to see if there's a way to get it into an investment account rather than owning the certificate itself. Make sure people know where to find your stuff. Don't hide it in a way that nobody will ever find it. We've had to do probates and conservatorships when somebody had a trust because there's an account in a trust and nobody can find the document. So just make sure people know where to find it. Personal property can also be sometimes create a huge headache because somebody wants something that has literally no value, but all of the children want it. You can do a personal property list where you list who gets what thing, or we can say in your documents that we're going to do it by lottery. Kid number one picks first, then kid two, then kid three. And so we're going to go around in a circle until all the stuff is gone, and then we can either sell, donate, or discard it. If somebody wants something, have them tell you. Put it on the list. You'll be all set. It's important to review your documents on a regular basis. People's names change, your relationships with them change, who you actually want to be your decision makers change. People pass away that you have listed in your documents. So people always laugh at me, but I say pull out your estate planning binder every New Year's. You're only behind by 21 days right now. And you can look at it and say, hey, this all still works for me. Nope, this doesn't work anymore. I haven't talked to this person in forever. Oh, I see that this person's phone number or email address changed. Let me make sure I can get that updated. Don't write on your estate planning documents. They're witnessed and notarized. Do it by a separate sheet that you can put on the top that says Mary Jo's phone number is now this. Mary Jo is now known as Mary Smith, whatever that is. But don't write on your estate planning documents. We can make amendments to them, we can change them, but it has to be done separately, not right on them. So just make sure they still work. The only assets that go through probate are assets that are in a deceased person's name with a value over the amount of a small estate affidavit, $75,000 if it's personal effects, and I think it's $100,000 equity in a house. If there's a joint owner, as I said, goes to the joint person. If there is a beneficiary named on the form with the institution, it goes to the beneficiary. If it's in a trust, we follow the terms of the trust. If it does not meet any of those categories, even if you have a trust, but you didn't title it to the trust, we probably will need to open a probate with the court so that we can then transfer it over to the trust account to the person who should be managing it. So just be conscientious about how things are titled. If you got divorced, make sure, even if you want your former spouse to get your life insurance policy, that you re-sign a new beneficiary form after you get divorced. Because if it's not an employer plan, it's just under Arizona law, that person cannot be your beneficiary or your decision maker unless you've done your documents after the divorce. They get removed by operation of law because the legislature knows that we're all slow in doing things, but we probably did not intend for our divorced spouse and their children to inherit from us or be our decision makers. So I'm going a little quick because I only have about 10 minutes left. I have a tendency to talk a lot. So obviously, if you have questions, you can send them to Matt or I. Happy to set up a consultation with you, doing the best that I can. And Sarah will make sure that the slides are available. Sarah in our office. So if you have a safety deposit box, understand that only the person who's the signer on the box can get into the box. So if it's in your trust, your trustee, after you pass away or incapacitated, should be able to enter it. If there's a probate and it's in your name, then the personal representative will be able to get into the box. But otherwise, nobody else has access. And if we lose the key, it costs somewhere between $50 and $100 for the bank to drill it and therefore for you to get the stuff out. And if you don't keep anything in your safe deposit box, I would really recommend that you just close it. So we're not looking for something and you're spending money maybe for your personal representative to drive to the bank, have it drilled to open it. And as I found out recently, as trustee of somebody's trust who had passed away, I found a rubber band. And they had the biggest safe deposit box I have ever seen at the bank. So just keep track of what your stuff is and then make sure that there's going to be an easy way for somebody to access it so that we can manage those assets. I recommend in your estate planning binder or however you keep your estate planning documents that you have copies of your beneficiary forms. Those institutions will only talk to the people listed on the form. So even if you have a trust, if you've named your 3 kids as the beneficiaries of the IRAs, you should have a copy of that beneficiary form with your estate planning documents so that then the trustee or whoever finds the binder can say, you 3 are the named beneficiaries. Here's all the information about that retirement account. they can send in their claim forms and collect their money. So I like to have those as in your binder. In the binders we have a section called assets, and that's a really nice place to either do an Excel spreadsheet of all of your accounts with the account numbers, or have just the first page at least of each account that you have so we know where the assets can be found. So one other thing I should have said, in your healthcare document, you can name, but you can say whether you want to be buried or cremated. I think it's really important to do that because if you want to be cremated, but you didn't put that in your document, then it will take all of the kids, if your spouse is deceased, to consent to your cremation, or you will need a court order to do so. So the Attorney General form has a place where you can initial. When we do healthcare powers of attorney, we put that language in there as well. So I did not see any Q&As or chats. So I have these two all text questions and I have a few minutes left. If you have any questions, you can certainly put them in the chat box or the Q&A and it'll pop up so I can see it. So one person has asked me, how do we preserve assets when we have a married couple and one of them might need long-term care benefits and they're not going to have enough money to pay for those that long-term care? Understanding that long-term care, to have somebody in your home, is probably between $30 and $35 an hour, and that is not for a nurse. That is for a caregiver who can do light housekeeping, some meal preparation, remind you to take your medications, and make sure you're safe in your house. To go to a facility, assisted living, group home, you're probably looking at somewhere between probably $6,000 and $10,000 a month. If you need a skilled nursing facility, because you need a wake RN and doctor 24/7, you're probably looking from $10,000 to $15,000 a month. So if you don't have long-term care insurance and you don't have a lot of money, or you die earlier than your money runs out, it's not an issue. But if you're concerned that you're not going to have enough money, or that you're going to spend all the money and there won't be anything left for your spouse, then Altex, the Arizona Long-Term Care System, is the thing that pays for long-term care services. If you are married, transfers between spouses do not impact eligibility. So we often have, if possible, the accounts end up in the well spouse's name. If that is so, usually that's possible. Usually we can figure out a way to make it happen. If in fact you have powers of attorney, those powers of attorney should say that gifts can be made to your spouse if you're comfortable with that. And then there is one kind of annuity, we don't sell any products, that can be used at the time of application and not beforehand to typically preserve all of the assets for the spouse who does not need care. And then the person who does need care, a portion of their income would go to pay for it, but all of the assets typically can be protected. Not all the time, but a lot of the time. Second homes, extra land, things like that make those applications much more complicated. But if we're talking about a house and money and you're married, then we can usually come up with a plan that will work to preserve those assets. You can certainly spend all your money. Person on Altex can't have more than $2,000 in their own accounts at the end of any month. But that's not very much money, and the number hasn't changed since the program went into effect in the 60s. So even for single people, we can often come up with a plan to try to preserve some of that money, understanding that Altex has a right to ask for all of the financial statements in either the husband's name, the wife's name, or the spouse's name, I should say, or a trust that benefits either one of them for the last 5 years. So if you make a transfer of assets to somebody other than your spouse, and it happened within 5 years of the date of the application, there may be, it would need to be disclosed, and there may be a penalty period or waiting period before those assets don't count anymore. So those are things to think about when you're making gifts. Now, it's a penalty of approximately Can you hear me now? Okay. It's a penalty of approximately for like 80, every $8,900 you give away is 1 month of a penalty. So if you gave $50 to each of your kids at Christmas time, I don't worry about that. But if you're giving large sums of money, understand what the impact might be on eligibility. So let's look at, uh, again, so a question is what's needed to prepare for All-Tex for the future? Again, there's a 5-year look back period. Typically, trusts don't help you. If you are still, you or your spouse is the beneficiary of income or principal, those are fully counted assets. If you transfer your assets to your kids and your kids set up the trust, we have 5 years that we have to disclose transfers, and then the money in the trust doesn't matter anymore because it's not yours. When I say 5 years, that's a disclosure period. If you give away $100, you don't have to wait 5 years before you get All-Tex. Okay? It's that you have to disclose if you made transfers and you didn't get fair market value in return within 5 years of that time of the transfer, from the time you apply, looking backwards. By the same token, it's not a limit on how long you have to wait. If you give away $10 million, I can't do the math in my head, but you might have to wait 30 years before you're going to get on All-Tex benefits. So you have to disclose assets you gave away within 5 years of the time of the application, and the waiting period to then get on benefits, assuming you're eligible, depends totally on how much money you gave away in that 5-year period. There are some exclusions, like for disabled or minor children. So there's an exception to every rule, but that's the general rule. When changes are made to your state documents, such as email, phone numbers, those changes need to be notarized as well. Again, don't write on your documents, but no, you can do a separate sheet that just says Joe Smith's new address is this, date it and sign it so we know it was from you, and that will work just fine. Our son has a special needs trust, and listening to this makes me realize probably our estate plan should be looked over. We created it in 2019 when we came to Arizona, but maybe there are some issues that we would like to have reviewed. We are more than happy to help you review that. You can call our office, and we're happy to take a look at your estate plan. No problem at all. And which leads me to another question that I usually get, which is my documents were done in another state. Are they valid here? And the answer is estate planning documents are valid in all the states as long as they were validly executed wherever you signed them. But sometimes they will need updates. We talked about the mental health power of attorney. That's kind of an Arizona thing. But they should be valid from state to state. Is it an issue using a friend versus a sibling for healthcare power of attorney? No, you should pick the right person. And you shouldn't just pick your oldest kid because they got here first. You want to make sure you have somebody who is not going to be intimidated by the medical professional, is going to be comfortable if they have to go into the hospital, somebody who will advocate for you and not just say yes, somebody who's going to ask for second opinions. You want the right person, not just any person. Do letters saying what I want need to be notarized? So when I was talking about the letter of intent, it doesn't have to be notarized. It doesn't hurt for it to be notarized. Then we know it was really you. So, and you can type it up, but then you should definitely sign and date it. And sure, if you can get it notarized or get it witnessed, that's terrific, but it's not required by statute. And then IRAs cannot be part of a trust. While I am alive, my retirement account, 401k, IRA, SEP, whatever it is, 403b, they have to be in the name of the wage earner. You can name a trust as the beneficiary of that, but the title is not in the name of the trust. The title is the wage earner. If you have inherited an IRA, it's going to be the Joe Smith inherited IRA for the benefit of Emily. So those don't get titled in a trust. If the trust is the beneficiary, then it's still going to be in a retirement account and then pay out through the trust for whatever those payments are. And I guarantee to you, no financial institution has put your personal IRA in the name of trust. The IRS would see that as a transfer, and you would have, or a liquidation, or whatever it would be called, and you'd owe all of the income tax on it. So I don't think that would have happened. Um, my wife and I have a well written, I think that's what it says. Oh, a will written by my firm. I thought it said a well written document by our firm. Anyway, we were told that a trust was not necessary. Has that changed? If your circumstances don't need a will and you just have beneficiary designations on everything, maybe you have one kid, you don't need to have a trust. If everybody needed a trust, we wouldn't have just wills, right? So I'm happy to talk to you again and make sure that that meets your needs. But I feel confident that we had that conversation and determined that a will-based plan would work fine as long as you have beneficiary designations on all of the assets. What is the term for protection of wealth before the 5 years for all tax? I'm not understanding that piece. There isn't a term for it. I'm just saying that if you give away an asset for less than fair market value within 5 years of the date you apply for all tax, you have to tell all tax. As a result, they will look at the total amount of assets that were given away in that 5-year window to determine when they will start helping you pay for care. So if you give away $16,000 within 5 years of the date of the application, you apply, you meet the income criteria, the asset criteria, and the medical criteria, they will say you have to wait 2 months before we will pay for care costs. Now, it takes Alltex about 3 to 6 months to process the application, so it won't matter, but that's how that works. I own a quarter of a farm in Michigan. I have 3 siblings. Does my 1/4 of the farm go to my siblings, or can I give it to my nephew? I don't know the answer for sure to that question. If you have your deed set up joint tenants with right of survivorship or community property with rights of survivorship, you don't actually own 25%, as it were. If you own it as tenants in common, yes, you can absolutely say that your quarter goes to whoever you want. If Michigan has beneficiary deeds, you can do it by a beneficiary deed. If they do not have beneficiary deeds by some name, but you have a trust, you could have your 1/4 interest titled to the trust, and then your trust document would say what happens to it. But it just depends on how that account or how that deed is set up as to how you would make sure that your share goes the way that you want it to go. So I hope that you learned something you didn't know when we started this. It is recorded, so if I talked a lot and you need to go back, you can look at parts of it. We look forward to your questions. We try to do these webinars once a month on a Wednesday, and so keep your eyes open for our next presentation, which Matt's going to take the lead on in February. And so thank you all for joining us. We look forward to the opportunity to assist you in some way, and we wish you the best until we see you again. Thank you. Bye-bye.